Well, good morning again, everybody, and welcome to Landmark Chambers' webinar on the highly topical issue of the impact of company voluntary arrangements, with particular reference to landlords and sureties. My name is David Nicholls, and I'm chairing this morning's event. We are delighted to see so many of you joining the session today, and we hope you will find the presentations and discussions useful and informative. Before I introduce the session and our speakers, may I begin with a few housekeeping points. First of all, your microphones are automatically muted, so you do not need to adjust your local settings. We very much welcome questions throughout the session. Please submit them via text in the Q&A section, which may be found at the top or bottom of your screen. We will endeavour to answer as many questions as possible at the end of the presentations. And the webinar will be recorded. You will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. Turning then to our speakers, I'm very pleased to introduce two of our property and insolvency specialists, Camilla, Lamont and Evie, Barden, who will cover topics such as the new moratorium in relation to CVAs, the possibility of forfeiting a lease in the event of a CVA, and authorised guarantee agreements. Camilla is going to speak first. She is a barrister and mediator who specialises in all aspects of property litigation, but with a particular emphasis on commercial and development work. She acted for Debenhams in relation to the successful challenge to its company voluntary arrangement last year, and she has advised both tenants and landlords in respect of several high-profile CVAs. She is an editor of Hill & Redmond's Law of Landlord and Tenant and has previously taught at Oxford University as a lecturer on commercial leases and real property. Camilla has been ranked for many years in the legal directories as a leading junior in property litigation, and she was named Real Estate Junior Barrister of the Year at the Chambers and Partners UK Bar Awards in 2017. She has been described as tenacious, bright, and a creative advocate. Camilla will be followed by Evie, who joined Landmark earlier this year. She is a member of the Attorney General's C panel, and she acts for creditors and debtors as well as office holders. She has particular expertise of cases involving insolvent tenants, including those who have gone into CVA, as well as insolvency cases concerning guarantees. Evie has been regularly instructed since the start of the pandemic by landlords and tenants in cases with insolvency implications arising from the financial effects of COVID-19, including being instructed in a challenge by a landlord to a high street retailer's CVA, and also in relation to an authorised guarantee agreement as to whether it has been discharged or modified by the CVA. On that note, Evie will speak second about how CVAs impact on the obligations of sureties. First, however, I invite Camilla to start with her presentation in relation to CVAs and landlords in the second wave. Camilla, over to you.
Thank you, David. Hello, everybody. It's very nice to see you all here. I'm going to talk about CVAs and landlords in particular. CVAs are essentially, I think of them as the property and insolvency equivalent of Marmite. Some applaud the CVA as a flexible and effective restructuring tool, which facilitates the survival of companies to the advantage of both creditors and society more broadly. However, others consider the CVA jurisdiction not only to be unfair, but also to be ineffective, allowing failing companies to continue to trade at the expense of landlords without actually incentivising the strategic changes that are actually needed to turn around failing businesses. So as we face a second wave of the COVID-19 virus, the retail and hospitality sectors are experiencing their own new wave of CVAs, with a number having been proposed and approved this autumn, including the controversial new look CVA. So I think it's a good time to take stock of where the CVA jurisdiction is at right now and where it might be going. I'm aware that many of you will be well aware of the basics of CVAs, and many of you have considerably more experience than that. Just to recap, a CVA is a statutory procedure contained in Part 1 of the Insolvency Act that enables a company to make a proposal to its creditors for a compromise of its unsecured debts and liabilities. And if at least 75% of the creditors voting on the proposal vote in favour, then it will take effect against all creditors, whether they voted for it or not. There is a challenge under Section 6 of the Insolvency Act 1986, based on either material irregularity or unfair prejudice, to which a 28-day time limit applies. Unfair prejudice is to be assessed in the round using two comparators as guides. The vertical comparator compares the creditor's position under CVA with that under the most likely alternative scenario, most usually administration or liquidation. And this sets a lower bound below which a CVA cannot go. The horizontal comparator focuses on the differential treatment between creditors amongst themselves. Whilst differential treatment is not prohibited, it must be justified. Until recently, only companies could obtain a moratorium on enforcement to enable them to take stock prior to making a CVA proposal to creditors. Even then, the small companies moratorium, which has now been repealed, was rarely utilised. That has all changed with the introduction of a new statutory moratorium under Part A1 of the Insolvency Act by the Corporate Insolvency and Governance Act 2020, which was effective from the 26th of June 2020. Detailed consideration of the moratorium is outside the scope of this talk, but in essence, directors of distressed companies are able to seek a short moratorium to give themselves a payment holiday and breathing space from enforcement or insolvency proceedings brought by certain classes of creditors, which would include landlords. So just to recap on the criteria for the moratorium, the company must be likely to be or be unlikely to become unable to pay its debts, and an insolvency practitioner acting as the monitor must certify that it is likely that a moratorium would result in the company being rescued as a going concern. In most cases, the moratorium can be obtained through a court e-filing, but can only continue beyond 40 business days with the creditor or court consent. Where the moratorium is in force, the directors continue to run the company, but the moratorium is overseen by the monitor, who has the power to terminate it. An important limitation is that the moratorium does not affect financial services contracts, which would include commercial lending. An important limitation of the moratorium is that it does not affect financial services contracts, which would include commercial lending. During the moratorium, a landlord will only be able to exercise a right to forfeit or take court action, including issuing a winding up petition with the permission of the court. Landlords will not be able to make an application for permission for the purpose of enforcing pre-moratorium debts, for which the company has a payment holiday during the moratorium, and that will include rent arrears that are payable in respective periods before the moratorium. Currently, tenants are protected against the threat of forfeiture for non-payment of rent by Section 82 of the Coronavirus Act 2020. And so there's little need for companies to go to the additional expense of seeking an A1 moratorium in support of a CVA. However, as and when the restrictions imposed by Section 82 are lifted, we might expect to see greater use of the new moratorium to prevent precipitous enforcement action by landlords while CVA proposals are being considered. If a CVA proposal is made during the initial period of the moratorium, it will be extended automatically until the CVA procedure has been disposed of. It's not clear how popular the new moratorium will prove to be in the context of CVAs. the statutory requirements of the A1 moratorium may limit uptake. In particular, the company will have to continue to pay the contractual rent and service charges in full for the period of the moratorium, which may not be attractive, particularly given that many CVAs seek to write off or at least substantially discount the rent right up to the date on which the CVA is to take effect. Before I go on to the substance of changes affected by the CVA, I'd like to just have a quick word about the calculation of landlords' voting rights. This remains a bone of contention, particularly the application of an arbitrary percentage discount once the value of landlords' claims in respect of future rent and dilapidations have been worked out by way of a formula. Given that the authorities say that the chair only has to attribute a value of £1 to contingent future claims in the absence of clear evidence of their actual value, and given that CVA proposals generally do include some generic formula for placing a value on such claims, one might argue that something is better than nothing. Nevertheless, the practice of applying an entirely arbitrary discount on top, having applied the formula in the first place, remains potentially open to challenge. Restructuring professionals may be wary of future challenges on this basis, as I see some evidence of lower discounts being applied than historically was the case. Ultimately, it will take a case in which the calculation of landlords' votes is material to the outcome of the voting procedure before the courts will be able to rule on the legitimacy of what is now standard practice. Moving on to rent, which is probably the most contentious issue under CVAs. It is a common feature of most CVAs that they seek to reduce the amount of rent payable by the tenant company going forward. Last year, in Discovery Northampton Limited versus Debenhams Retail, a group of landlords who were funded by Mike Ashley of Sports Direct sought to challenge Debenhams CVA on the alleged basis, amongst others, that a CVA could not be used to reduce future rents at all. This argument was rejected by Mr. Justice Norris, who reviewed all of the authorities in some depth and concluded that future rent could be compromised in principle by the CVA. In that case, the judge also rejected the submission that the CVA was unfairly prejudicial because it allowed the company to continue to trade for the benefit of all creditors at the expense of the landlords, picking up on some dicta of Neuberger in a earlier case called Ken Thomas. But that argument was also rejected, and the judge set out what he considered the basic constituents of basic fairness to be. Basically, the landlord should receive at least the market value of the rent property he is providing. He should not subsidise other creditors, but nor should they be required to compensate him. A contractual rent should be interfered with to the minimum extent necessary to achieve the purpose of the CVA. So whether a CVA is unfairly prejudicial to any creditor is ultimately a question of fact, to be assessed in the round, adopting vertical and horizontal comparators as useful heuristics. And this aspect of the Debenhams decision represents a very strong judicial endorsement of the CVA as a tool for restructuring over-rented lease portfolios. Until quite recently, it was usual for a CVA to impose percentage deductions to fixed rent by reference to each store's desirability from the tenant's perspective. However, the CVAs now being proposed are more likely to seek the introduction of a turnover element. We all know that turnover rents are popular with tenants who are looking to landlords to share the burden of the economic fallout from the pandemic. Landlords and tenants are encouraged by the new code practice to act as economic collaborators as opposed to economic opponents, although quite where the line is to be drawn is not yet clear. At the frontier of this battle is New Look, whose CVA, which was approved, is effective to move 400 plus stores onto turnover rents, but is being challenged under Section 6 of the Insolvency Act by a number of landlords, including British Land and Land Securities. Whilst many landlords will accept turnover rents as an immediate solution to the problems thrown up by the pandemic, they will not want turnover rent becoming the norm. turnover rent provisions require careful consideration and are usually negotiated between lawyers acting for each party on a case-by-case basis, although there are efforts to introduce industry-wide standards. In contrast, a CVA would impose pro forma turnover rents on a take-it-or-leave-it basis, which leaves little, if any, room for consideration of the appropriateness of the drafting in respect of individual premises. This could prove significant, particularly as to the extent to which the definition of turnover truly captures the value of the store's contribution to the company's online sales. So looking forward, the rents approved under CVAs, such as the introduction of turnover rents into most of new looks leases, may start to actually drive market practice rather than merely reflecting it. In Debenhams, the judge accepted uncontested evidence that all the stores were over-rented, and the applicants did not contend in that case that the revised rents fell below market values. Benchmarking CVA rents to the level of open market rent is important in considering the overall question of prejudice, because there will be unfairness if the landlords are expected to take reductions in rent below market value, as Norris made clear in the Debenhams case. However, a difficulty for landlords is where turnover rents are proposed, it will be far more difficult to assess whether landlords would get better terms were they to go to the market. And this would make applying the vertical comparator far more difficult. It is now common for CVAs to include break provisions operable by landlords who are to take a hit on rent, essentially as a quid pro quo. The argument being that the landlord is then free to take back the premises and take its chances on the open market if it considers it would do better there. In the Debenhams case, an argument to the effect that the introduction of new break provisions in favour of landlords did not do enough to redress the imbalance were ultimately rejected. So it will be interesting to see whether challenges to the introduction of turnover rents by CVAs find favour with the courts. With turnover rents becoming more prevalent and many valuers opining that retail property is effectively unlettable in the current climate, it is not immediately obvious that a landlord will be able to sustain challenges to turnover rents on the basis of unfair prejudice, particularly if the vertical comparator is administration or liquidation, as it invariably will be. So we wait with keen interest for the outcome of the recent challenges. Whilst challenges to rent reductions have not found favour with the courts, there have been better news for landlords when it comes to challenging attempts to restrict their proprietary rights. And in this respect, two recent cases have been held as victories for landlords. The first was Debenhams itself, where Norris held that a CVA could not, as a matter of jurisdiction, be used to abrogate a landlord's proprietary rights. As a result, a CVA cannot prevent a landlord forfeiting a lease for an insolvency event, such as the proposal and or making of the CVA itself. Whilst the CVA can release or reduce the rent, and as such prevent the landlord from thereafter forfeiting in respect of non-payment of rent that has been compromised and is no longer due, the right of forfeiture itself cannot be abrogated. And the Debenhams case is important because most commercial leases will include an insolvency event forfeiture provision, and therefore the landlord effectively has an opt-out provision if it does not like the terms of the CVA being imposed on it or wants to take back the premises for other reasons. In a rising market, these rights will be extremely valuable. However, the economic outlook is bleak, and the old adage that the grass is not always greener applies. Whilst landlords complain about the CVA jurisdiction, the reality is that more often than not, they vote in favour of CVAs. For example, of its landlords who voted in respect of the Debenhams CVA, 82.1% by value voted in favour of it. And similarly, it is not commonplace for landlords, even dissenting ones, to exercise forfeiture rights if a CVA is approved, certainly not in current market conditions. The second case was reinstant cash loans, in which Mr. Justice Zaccaroli held that a scheme of arrangement under the Companies Act, and likewise the same reasoning applies to CVAs, could not be used to force a landlord to accept surrender of a lease on the basis that the termination of the lease affects a substantive change in the nature of the landlord's interest in the property. The case is of practical significance because prior to instant cash loans, many CVAs incorporated agreements to surrender stores that were to be closed, which, if enforceable, would have meant that the landlords would become liable for empty building rates. Therefore, where there is a proposal to close a store, a CVA is now likely to seek to compromise all of the tenant's obligations on the lease, whilst at the same time conferring on the landlord a right to accept a surrender of the lease at a time of its choosing, rather than imposing that surrender on it. Turning to some practical matters for landlords, if a landlord wants to forfeit a lease in the event of a CVA, there are a few obvious do's and don'ts. First of all, do check the lease terms to see what the forfeiting event actually is, and serve a notice under Section 146 of the Law of Property Act in advance, giving some thought to how long you might need to give the tenant to comply, assuming that the breach is remediable, which may itself need some thinking through on the facts. Take care not to waive the right to forfeit, and in that respect, think very carefully about whether, and if so, the landlord should vote on the CVA proposal. I would generally say that voting in favour of a CVA and then seeking to forfeit off the back of it is likely to encounter some tenant opposition, regardless of the legal rights and wrongs. Technical waiver arguments might also be raised where a landlord votes on the basis of a voting calculation that assumes the existence of future claims under the lease, however it votes, because this might arguably be said to constitute an unequivocal recognition of the continuation of the lease. You've got to decide, in a sense, whether to forfeit or not. If a CVA incorporates a new break provision in favour of a landlord, the landlord will want to consider with some care whether it would be better off terminating the lease under the CVA break option or forfeiting outside of the terms of the CVA. And considerations will include the position of subtenants as well as the treatment of fixtures and dilapidations. Critically, it's not yet clear how the courts are likely to respond to relief applications made where a lease is forfeited by reason of a CVA being proposed or entered into by a tenant, particularly in the post-COVID era. As you all know, the discretion to grant relief under Section 146 of the Law of Property Act is extremely broad. One would ordinarily, although not invariably, expect the breach to be remedied as a condition of relief being granted. However, what does remedying the breach look like in the context of a CVA? Does this mean that the CVA would have to be revoked entirely, or alternatively the lease assigned to a fit and proper person, even assuming that were possible in current market conditions? Or would it be enough for the tenant to agree to pay the contractual rent to the landlord in question despite the terms of the CVA? And even if the CVA were revoked, would that fully compensate the landlord from any stigma there might be from the CVA proposal having been made in the first place? And even more, perhaps theoretically, could a tenant get away with seeking unconditional relief, thereby forcing the landlord to accept the terms of the CVA? Applying conventional principles, this would seem a very startling proposition, but we are living through strange times. No doubt we all have our thoughts about how the relief jurisdiction should be exercised, but the reality of this is that all of this has yet to be hammered out by the courts, and every case will turn on its own merits. So just to conclude, in my view, despite the cost and uncertainty that's inherently involved in challenging a CVA, it is important that the limits of the CVA jurisdiction are tested by the courts from time to time, because the CVA jurisdiction is likely to play a significant role in determining where the line is ultimately to be drawn between landlords and tenants in what are likely to be very difficult times ahead. So if at least one of the new look challenges does see the inside of the courtroom, even if only virtually and even if only on audio, the courts will be given the further opportunity to consider the limits of this important and wide-reaching jurisdiction. And I look forward to seeing the outcome of those challenges. So thank you very much for bearing with me and my video audio difficulties. I shall now hand over to Evie Barden, who is going to be looking at the particular issue of CVAs and sureties.
Thank you, Camilla. I'm going to talk about how CVAs impact upon sureties obligations. So what is a guarantee? At risk of teaching grandma to suck eggs, a guarantee is a subset of an indemnity, i.e. the right to look to someone else to satisfy your losses. And although you can find contracts where you have both guarantee liability and indemnity liability on the part of the surety, guarantees are distinct from indemnities. You get many different variants, but at its core, the quotation on the screen from Dennis and the Commissioners for Her Majesty's Revenue and Customs sets out nicely what it is that a guarantee is. And what it is a liability that is contingent on the principal's liability. The surety is either paying the principal's obligations, which can be in default of the principal complying with their obligations or concurrently, or is liable to perform some other obligation. And crucially, on payment, the surety then has a right to an indemnity from the principal. The surety stands in the shoes of the creditor in order to be able to recoup the sum paid to the creditor. And that is important to bear in mind for the purposes of what might occur with CVAs. It's the principle of co-extensiveness which is set out in Dennis. And looking at that in a bit more detail, the principle of co-extensiveness links in with the idea that discharge of the principal leads to discharge of the surety. And there's a very good quote about this from a Canadian case, Canadian Permanent Trust Co. and King Art Developments Limited, which is that prima facie a guarantor's obligations are co-extensive with the principal debtor, but the starting point must always be to analyse the nature of the guarantor's undertaking. Depending on the terms of the guarantor's obligation, his obligation may persist even though the creditor is temporarily or permanently disabled from pursuing the debtor to collect the debt. It is important to an analysis of the problem to remember that although the obligations of the surety and the principal debtor are often coextensive, they are nevertheless separate and distinct obligations. Though coextensiveness of the obligations of the debtor and surety may be varied by the surety's contract with the creditor, I have difficulty in envisaging a situation where the contractual term would hold a surety liable when the debt guaranteed has been paid. The essence of suretyship contracts is to see that the obligations between the debtor and creditor are satisfied. So as a matter of principle, the reason why payment or release of the principal discharges the surety is that the underlying basis of the surety's obligation is payment of the debt or performance of the obligation of another. So once payment has occurred or the obligation has been released, there is nothing in respect of which the surety can be liable. And secondarily, the effect of the release is to deprive the surety of the right to sue the principal in the creditor's name. So that's payment or release. But what about variations to the principal's liability? And this is where what is known as the rule in Holman Brunskill comes in, i.e. a surety is just discharged if the creditor agrees with the principal debtor to vary the terms of the contract guaranteed, unless it is self-evident the variation is insubstantial or one which cannot be prejudicial to the guarantor. Under that rule, the court doesn't examine whether or not there is actual prejudice or damage. It must be self-evident that it is not the case there would be, or that the variation is not substantial. And that applies equally in landlord and tenant cases. So if it's not clear that the obligation is not more onerous, the surety will be discharged. And you see that in Holman Brunskill itself. Surrender of part of the land meant it was potentially harder to perform the obligation to deliver up a flock of sheep at the end of the term in good order, which is what the guarantor had guaranteed. But express words in the guarantee can prevent such a release. Like with all points of construction, it depends on the words of the guarantee, but beware the trend in recent cases for the courts to interpret those sorts of clauses which provide variation of the principal's liability will not discharge the surety very restrictively, often against the creditor and in favour of discharge. So you may now be wondering, how does this all connect with CVAs? As Camilla has already said, a CVA is a compromise of a principal debtor's liabilities with its creditors, where creditors are bound even if they vote against it if the CVA is approved. But a surety isn't a creditor of a company where there is an outstanding guarantee which has not yet been enforced, and so they're not bound by the arrangement. The effect of Section 5 and the binding of creditors has been discussed in a number of cases, which all discuss what is known as the creation of the statutory contract or the hypothesis of the statutory contract. An in-depth discussion of those cases is beyond this talk, but a high-level summary is that the CVA establishes a contract, but not for all purposes. I think the most important cases here are Re Britannia Heat and Re Rhino Properties Limited. In Re Britannia Heat, His Honour Judge Norris, as he then was, said, the fact that a CVA is a creation of statute designed to achieve a particular end and rests not upon the actual consent of those bound by its obligations, but upon adherence to a specified procedure. And in Re Rhino's property, although an interim hearing, the court concluded that it was at least strongly arguable, having gone through all the authorities, that a CVA is not actually a contract, but a quasi-contract, which can, by a statutory mechanism, bring about variations in contracts, which is not dissimilar to what Christopher Plymont QC, sitting as a Deputy High Court Judge in Re SHB Realisation, said, which is that case about CVAs and penalty clauses. In that case, he said, the fact that the CVA has contractual effect does not mean that it has every attribute of a contract or every principle of the law of contract applies to it. So where does that leave us with the surety's obligations? On the right-hand side of this slide is a photograph, I think, of the Liverpool store in the mid-60 case, 60 UK and Morant, which is well known if you know about CVA cases. It's the second in a set of cases, the first being Prudential Assurance Company Limited and PRG Powerhouse. And that Powerhouse case is the one which established the validity of what was known as guarantee stripping, i.e. that while a guarantor is a third party to a CVA and not bound by it, the CVA can validly strip the creditor of their rights of recourse against that third party. Both the Miss-60 case and the Powerhouse case were examples of challenges to CVAs on the basis that they were unfairly prejudicial, and in both cases the challenges succeeded. The thrust of those cases is that while it turns on the facts of every case, it will be a very rare case indeed where guarantee stripping will not be unfairly prejudicial. Effectively, the CVA supervisor is probably going to have to show that the guarantees aren't valuable. And given the heavy criticism that came to bear on the CVA supervisors in the Miss-60 case, we have largely seen provisions like that relegated to the bin. So you may be wondering, what's the point with this talk if guarantee stripping is a thing of the past? Well, notwithstanding that there is no real existence of express guarantee stripping in CVAs now, you may find that landlords are without their rights of recourse against guarantors, or at least arguably so. And that's because of what Lord Justice Chadwick said in Johnson and Davis, which is that it's up to a debtor to propose and for creditors to accept or reject proposals which either do or do not have the effect of releasing sureties. As a matter of principle, the submission that no term in a voluntary arrangement can have the effect of releasing a co-debtor or surety was rejected in Johnson and Davis. What the court said is that, in my view, the effect of a voluntary arrangement has to be determined by construing its terms. And while Johnson and Davis is a case on IVAs rather than CVAs, it was held to be good law in the Miss-60 case and the Powerhouse case. So where does this leave you if you're a landlord with a guarantee? We're back to thinking about the rule in Home and Brunskill, i.e. has there been a variation which is not consented to and which is not insubstantial or could be prejudicial to the surety? If so, the surety will be released. So what you need to be thinking about if you're looking at this is, First, is there an anti-variation or anti-indulgence clause in the guarantee or side agreement? What does that provision say? Does it preclude a release occurring because of the CVA? Second, what does the CVA provide for as the new obligations, and how do they fit in with the obligations in the guarantee? Is there an argument about the obligations in the guarantee? For example, if a new future rent is payable which is lower, is the guarantor only liable to pay the lower rent under the terms of the guarantee? If so, is there an argument that the guarantor is not released because there is no potential prejudice? But query about the potential for prejudice even if it never materialises. And it strikes me that that is really quite potentially problematic in the area of the new turnover rents, CVAs, that Camilla was talking about. Yes, the idea is that rent is reduced because footfall is currently reduced, but is there not at least the potential that rent could increase above what is currently payable in if the CVA doesn't cap the rent? Third, if nothing else, is there a problem with the time of payment? Often a CVA compromises historic arrears, and those arrears claims will be allowed to be paid in instalments or over time, even if it's an 100 pence in the pound CVA. You'll see often time being given. The problem here is that the surety can't step into the shoes of the creditor and sue the principal on payment of their debt, because typically it is a condition in the CVA that there is a moratorium on proceedings against the creditor in respect of debts bound by the CVA. So under the general law, the surety would be discharged by the granting of further time. You also might see clauses in CVAs that say they don't modify the rights or liabilities of anyone other than the CVA debtor, but query how this can be binding on the surety if they're not a party to the CVA, and the general law would result in their release. I don't think that that sort of clause can preclude it. So if you've audited the CVA and the guarantee and you find you're left in a position where the general law probably means the surety is discharged, are there any other options open? More conceptually, I wonder about the underlying rationale in Johnson and Davis and whether the rule in Home and Brunskill really is in principle applicable to CVAs. The underlying basis of that rule is the situation is one where the creditor has transacted the business of the surety without their consent. But that doesn't happen in a CVA. The creditor may have itself voted against the CVA and then by the statutory deeming process be bound. So it's not based in consent like a bilateral variation would be. But we're going to need a very pugnacious creditor to take this point on, given that the rule, or given that the decision in Johnson and Davis is a Court of Appeal authority. So turning now on to the specific beast of the ARGA. As we all know, under the 1995 Act, a former tenant who would otherwise have been released from their obligation to perform a covenant can be bound. I've got part of section 17 up on the screen. That's the section you need to look to for the procedure if you're going to try and get your former tenant to pay up. And subsection 1 of that section provides that it's applicable where a former tenant is, as a result of an assignment, no longer a tenant, but has, under an ARGA, guaranteed the performance by his assignee of a tenant covenant of the tenancy under which any fixed charge is payable. What is a tenant covenant? Section 28, subsection 1 says it is a covenant falling to be complied with by a tenant of the premises demised by the tenancy. And then on your screen, you have subsection 2, which provides that a former tenant shall not be liable under the ARGA for any amount in respect of any fixed charge payable under the covenant unless a notice is served. So what is payable? Well, one argument is that the tenant covenant is the modified CVA obligations. And I haven't seen this considered expressly in any case, but in the Debenhams case, Mr. Justice Norris says the covenants under the lease have been varied because the rent has been reduced. Query though how that fits in with the SHB realisations case where Christopher Pymont QC rejects the idea that the lease has been varied because a variation of a lease has to be by deed. But is that correct? C. Williams and Carraway Limited which is the Regis Hair Salon CVA challenge, where the court on a summary judgment application held it was properly arguable that a CVA could give effect to a variation in equity, because in equity a deed can be varied by a mere contract underhand based on the authority of Berry and Berry, a case from 1921. So that's a bit of a mess, and query also how it fits with section 18 of the 1995 Act. This then leads me on to the final slide, which is some of the practical difficulties a landlord can find themselves in, or indeed any creditor with the benefit of a guarantee. In an application to challenge a CVA, a landlord or creditor will have to argue that the guarantee is not binding, but it may also separately want to try and go against the guarantor, and in doing so need to argue that the guarantee is binding and allows it to recoup any arrears from the guarantor. And so that's why you've got the photo of someone riding two horses on this screen. You've also got a timing problem potentially. As Camilla said, a challenge to a CVA needs to be made within 28 days of approval. And the point of that is so that the CVA supervisors and creditors are not left in limbo. But obviously, it may take you more than that time after the CVA approval to have any discussions with the guarantor and deal with any disputes separately. So it's probably not going to be resolved before any Insolvency Act challenge has to be made. And you'll probably struggle really to come to an agreement with a CVA supervisor, because any variation to a CVA would need to be approved by all creditors. The result is pretty unenviable for a landlord or creditor, and frankly, that's probably why many of them choose not to take the fight forward and to have the medicine of the CVA instead. But if you are going to challenge, I wonder if a practical route forward is to join the guarantor into the Insolvency Act proceedings and let them and the supervisor fight it out. I think I'm going to hand over now to David to deal with any questions that might rise.
Well, thank you very much indeed, both to Evie and Camilla, for those illuminating and thought-provoking comments. And if anyone listening had a little bit of difficulty at the beginning with the quality of the sound, we will try and edit that out on the recording, so you may be able to pick up on that if you watch again. We've had quite a few questions coming in, which is really, really good to see, and some very interesting points have been raised. We probably have time for one or two questions for our two speakers. So my apologies if you have asked a question and we don't get a chance to address it. My first question is in fact my own question, which is a general question for both speakers. CVAs have been described as being a bit like Marmite. They elicit very strong reactions. You either really like them or you really don't. And I would just like to ask Camilla and Evie what your opinion is of CVAs. Do you like them or not? Are they effective or not? Perhaps Evie, if we start with you.
I'm a great lover of Marmite on toast, but I find CVAs to be a bit more like honey than Marmite when I think about breakfast and toast choices. The reason I say that is I always buy the runny honey squeezy pots, and whenever I go into the cupboard, the pot inevitably hasn't been shut properly, and there's an almighty sticky mess that I have to clean up with, you know, rice, whatever else is spilled over in the cupboard. And just so with CVAs, even before the CVA is in progress, there is an almighty sticky mess that lots of different parties are stuck in. The drafting of them often leaves a lot to be desired. For one, they're done in haste. For two, often done by office holders rather than professional draftspeople. For three, pro formas are used. So you get all sorts of problems throughout the lifetime of CVAs. And just like with honey, it has the appearance of being a healthy, sweet treat, but actually when slathered on bread, doesn't sate your hunger for very long and is sickly sweet. So all the promises of 75 pence in the pound versus nil in liquidation draws everybody in, but in fact often leaves everyone, or at least the landlords, hungry as the company piles on further debt. So I'm afraid I'm a bit of a skeptic. Nice in concept, but you always feel after breakfast like you should have chosen a different condiment.
Well, so there we go, honey rather than Marmite. Camilla, what's your take on that analogy?
Well, I'm also a Marmite lover, but only if it's applied in a very thin layer on top of a lot of butter. And I think that a sort of an over-liberal application of Marmite is truly disgusting. And I think I feel sort of the same about CVAs, really. I think used well, they're a great thing. I mean, obviously, they've kept me gainfully employed for the last few years, so I'm like them for that reason. As Evie has said, they do throw out all sorts of fascinating questions where insolvency and property kind of collide. So I would say, used well, that they're a treat, but used badly, then they can go horribly wrong. And I think that there is potential for the jurisdiction for it to be abused. And classic examples of that are Powerhouse and the Morant and 60 case. Particularly the early examples of CVA, there were some quite horrendous abuses of it. But used well and how it's supposed to be used, I would be in favour. But I think those of us that advise landlords and tenants sort of have to sort of hover somewhere in the middle on this in any event.
That's very helpful. Thank you, Camilla. And I wonder if I can stay with you, Camilla, and ask a number of questions that have been put in really a bundle under the heading of challenge. If you're a landlord or maybe a surety disgruntled with the terms of the CVA, how feasible do you think, Camilla, it may be to challenge the CVA? What do you think needs to be demonstrated to have a chance of success? And can you give any specific examples of a successful challenge? What practical advice would you give to a landlord in that position?
I think it's very difficult for landlords because they're up against the juggernaut of the sort of insolvency process. And the reality is that it is very difficult to challenge a CVA, and it's very expensive as well. I mean, the costs in the Debenhams case ran into 7 figures. For one party. There were, I think, 12 counsel in the court at one point. It's certainly not something to be undertaken lightly. What I would say is that if you are going to challenge it, try and find someone else to challenge it with you. One thing that has astounded me is that landlords haven't really to date got together to do kind of class actions on these things, which would of course enable them to fund the litigation more proportionately. But if you can't do that, I would say, don't just do it on a whim. You have to have a good case. And I would say that basically, practically speaking, can you satisfy the lower bound test? In other words, if you can clearly show that you would do better on a winding up, then you've probably got a good case about the CVA being prejudicial, and you should go straight to the nominees and the tenant to try and get some amendment. But other than that, it's not something to be undertaken lightly, would be my advice.
Thank you, Camilla. And then a final question for Evie in relation to the interplay between a CVA and the 1954 Act. If a tenant is in a company voluntary arrangement when the lease comes to be renewed under the 54 Act, do you have any thoughts about whether the renewal process itself, assuming it follows the normal process with terms of a new lease being agreed or determined, is there the possibility of the CVA overriding those terms, particularly on the question of rent?
Well, I don't see how a new lease that has either been agreed or granted by the court after the CVA was approved can be impacted by an earlier CVA. I can see that the terms of the CVA might be a relevant consideration for the purposes of Section 35 and the terms of the new tenancy. And perhaps the rent payable under the CVA is indicative of what market rent might be. But the obligations under the new tenancy are new obligations, and they won't be caught by the CVA because it can only bind creditors of the company when the CVA is proposed. So I don't think that the CVA can have any impact on a new tenancy.
That's great. Well, thank you very much, Evie, for those comments. And I'm afraid as we come up to midday, I'm going to have to draw the webinar to a close. My thanks again to our speakers, and our particular thanks to our participants, and indeed for the questions which have been posed, which are still coming in. So thank you very much indeed for your thoughts. As I mentioned at the beginning, the slides and recording will be circulated to those who attended. Thank you and good afternoon.